Honorable Court of Appeals of Tennessee is now in session. You may be seated.
Good afternoon. Just a brief reminder that unless the case, it's been requested that the case not be live streamed and placed on the AOC website, the oral argument will be live streamed and placed on the website. So for whatever that's worth, keep it in mind. Call the first case, please.
Lakeway Real Estate 2, LLC versus Era Franchise Systems, LLC.
We'll hear from the appellant whenever you're ready.
Thank you, Your Honors. If I may reserve 3 minutes for rebuttal. May it please the Court, my name is Rebecca Harbin, and I represent the appellant, Lakeway Real Estate 2, LLC, and for ease of reference, I'll refer to them as Lakeway during this argument. This is a very simple
Counsel,
case.
do you want to reserve any time for rebuttal?
Yes, 3 minutes.
3 minutes?
3, yes.
That'll be fine.
This is a very simple case. It involves the interpretation of one provision in a contract. We respectfully contend that the trial court erred in its interpretation. This lawsuit was filed originally in Jefferson County Chancery Court. It concerned a certain franchise agreement between Lakeway as the franchisee and the appellee, ERA Franchise Systems, as the franchisor. Lakeway brought suit seeking to terminate the franchise agreement because ERA was the first to breach that agreement and failing to provide the essential services that the agreement promised. It also sought declaratory judgment that a non-compete was invalid as a matter of law. ERA filed a motion to dismiss under Tennessee Rule of Civil Procedure 12.023 and argued that a forum selection clause in the franchise agreement mandated litigation in New Jersey, and New Jersey law does control this contract. And that franchise agreement specifically provides as follows. As to venue and jurisdiction, you submit to the non-exclusive personal jurisdiction of the state and federal courts of the state of New Jersey for any litigation arising out of or related to this franchise agreement or to any aspect of the business relationship between the parties. Such litigation will have venue in state courts in Morris County, New Jersey, or in the United States District Court for the District of New Jersey. ERA argued to the trial court that this non-exclusive personal jurisdiction was simply permissive, that they could bring suit in New Jersey, but it doesn't divest any other court where jurisdiction is proper of hearing that case. And this is the entire crux of this issue before the court, is the interpretation of that clause. Alternatively, ERA argued that the non-exclusive personal jurisdiction in the forum selection clause mandated litigation in New Jersey, and the trial court granted that motion to dismiss based upon Tennessee Rule of Civil Procedure 12.023. The trial court held that the court finds that the forum selection clause in Section 22.7 of the parties' franchise agreement designates New Jersey as the mandatory venue for litigation arising out of or related to the franchise agreement or any aspect of the business relationship between the parties. And that's Technical Record Volume 1, page 109.
Counsel, doing your research, did you find any other cases that has interpreted that non-exclusive personal jurisdiction clause?
Yes, I did, Your Honor. It's in our brief, but I can touch on some of those cases. There was one in particular that we cited in our reply brief that actually had that non-exclusive language where the court found that it was permissive, and that's First Tech-Tex, Inc. versus PAC Corp., 2010, New Jersey Superior Court, unpublished, Lexus 484 at 334. The court examined that forum selection clause, where it was titled Governing Law, and it found that the word shall in relation to venue, the forum selection clause respecting jurisdiction merely stated that each party submits to the venue and jurisdiction of Maryland. The court then determined that nothing in that phrase indicates that the parties intended that Maryland would have exclusive jurisdiction over their dispute. And this is pretty universal in the case law, that a permissive clause authorizes jurisdiction in a designated forum but does not prohibit litigation elsewhere. And that's Global Satellite Communications Co. versus Star Mill UK Limited, 378 Federal 3rd, 1269. That's out of the 11th Circuit. And then, in contrast, a mandatory clause dictates that an exclusive forum for litigations under a contract. The general rule in cases containing forum selection clause is that when only jurisdiction is specified in the clause, will generally not be enforced without some further language indicating that the parties intended to make the jurisdiction exclusive. And so, in this case, because there's this non-exclusive phrasing, the court erred in ruling that we must bring the case in New Jersey. There is no argument raised by ERA that there was not proper venue or jurisdiction otherwise, solely that the forum selection mandated jurisdiction in New Jersey, and that's simply not the case. And in it, just one briefly, in a different New Jersey case, the appellate court agreed with the plaintiff's position as to a similar personal jurisdiction clause, wherein the clause stated as follows: defendant consents to the personal jurisdiction of the courts of the Commonwealth of Pennsylvania and Philadelphia and Montgomery counties, including the jurisdiction of the United States District Court for the Eastern District of Pennsylvania, and waives a trial by jury in connection with any action or proceeding in connection with this note. The court held that this clause presented a circumstance where the parties have merely consented to the jurisdiction and venue of a court that might otherwise lack them. It's not a direction that suit may only be brought in that particular forum, and that's the Bessler case out of New Jersey. And so we contend that the trial court erred in ruling that this case must be brought in New Jersey because it is a non-exclusive forum selection clause. It doesn't divest courts of proper jurisdiction from hearing the case. It only allows, it's permissive, it allows someone to bring the case in New Jersey. There's simply not that requisite language designating exclusivity that would support the trial court's finding that this is a mandatory forum selection clause. And so we would respectfully represent to the court that the trial court erred in dismissing this case under Tennessee Rule of Civil Procedure 12.023, and Lakeway requests that the court reverse the ruling of the trial court and remand the case for further proceedings. And I can answer any questions that the court has.
I hear none. Thank you. You have your time. Excuse me, you have your time for rebuttal.
Thank you.
We'll hear from the appellee.
Good afternoon, Your Honors. Jacqueline Fiala for the appellee. May it please the court? This appeal arises from a declaratory judgment action in which the appellant Lakeway sought judicial sign-off on its avoidance of its contractual financial obligations and its covenant not to compete contained in the franchise agreement between the parties. In fact, nearly exactly 2 months before this complaint was filed, ERA sent Lakeway a notice of termination of the franchise agreement. Lakeway beat ERA to the courthouse and filed this complaint on December 21, 2022, and in an attempt to forum shop, ignored the forum selection clause in the franchise agreement, which is mandatory in its wording. Now, the trial court correctly granted ERA's motion to dismiss under Rule 12.023 when it decided that the venue portion of the forum selection clause was mandatory. If we look at Section 22.7, I don't want to belabor the language, but I believe that when interpreting a contract and the party's intent, it's important to look very closely at the syntax and the words that are used in the contract itself. Section 22.7 is divided into 2 sentences and contains separate directives for personal jurisdiction and venue. The first sentence pertains only to personal jurisdiction, and the first sentence contains the permissive, non-exclusive term that appellant is basing its appeal on today. The second sentence pertains only to venue, and the second sentence contains the mandatory language, such litigation will have venue in state courts or federal courts in New Jersey.
Counsel, I think the difficulty with separating those 2 sentences out is because sentence 2 necessarily refers to sentence 1, because it says such litigation. Sentence 1 says you submit to the non-exclusive personal jurisdiction for any litigation, right? So that non-exclusive means it doesn't have to be just the federal and state courts of New Jersey. Those are not the only ones that have personal jurisdiction. We agree that's what that means, right?
Yes, Your Honor.
And then we move on to sentence 2, which says such litigation, referring back to any litigation, to me, referring back to any litigation that's filed in the state and federal courts of New Jersey. So the way the way your opposing counsel might read it, the way I might read it is such litigation means if you're going to file suit in New Jersey, like we say that you can, because we're saying that you submit to jurisdiction there, even though it might not otherwise have jurisdiction, then you got to do it in Morris County, New Jersey, or in the district court for the District of New Jersey. So why would we not read it that way?
Yes, Your Honor. Well, if we take that terminology or definition of litigation contained in the first sentence and plug it into the second sentence, it reads, any litigation arising out of the agreement or the business relationship of the parties will have venue in the state and federal courts of New Jersey. One can imagine instances that the parties may be engaged in litigation that would not arise from the franchise agreement or would not arise from their business relationship, or at least there may be an argument where that would be the case. For example, workers' compensation case, wrongful death or personal injury case brought by an employee of Lakeway using a company vehicle. A libel or defamation action may or may not arise out of the parties' business relationship, or the franchise agreement itself. So there are instances where there may be personal jurisdiction elsewhere, and that may be appropriate, but for instances where the litigation arises from this agreement or from the parties' business relationship, the second sentence is clear that that litigation will have venue in state courts. There's no doubt that this case is a case that arises from the parties' business relationship. It's a declaratory judgment action seeking clarification on the franchise agreement itself and the enforceability of the non-compete provision contained in it. This is an instance where the venue is mandatory in New Jersey, and the trial court respectfully decided it correctly and dismissed the case with prejudice. And I hope that answers your question.
Counsel, this went off on a motion to dismiss, correct?
Yes, Your Honor.
Was there anything in the record at the motion to dismiss stage showed us, they told the court which party was who did the contract? I know who signed it, but who prepared the contract?
Not to my knowledge, Your Honor, no.
So we don't know one way or another from what's in the record right now.
There's nothing in the record pertaining to the drafter of the contract.
Okay.
It is important to keep in mind that venue and jurisdiction are separate legal concepts, and jurisdiction pertains to a court's authority to hear a matter, as this court well knows, and venue is where the matter is decided. So those are dividable terms, and they needn't be both permissive or both mandatory. And if we look to the Western Refining case versus BP Corporation, that case is instructive here because that case contained both permissive and mandatory language in the same clause. We discussed it in our brief, and the court determined ultimately that because the mandatory language did not have a modifier attached to it, then the mandate of the clause was that the venue was mandatory. The venue selection clause was upheld, and the case was transferred to the appropriate court. Now, ERA is not arguing that Lakeway cannot file suit in New Jersey. That has always been an option open to it. It is not going to be prejudiced if this case is dismissed. And respectfully, we request that this court uphold the trial court's decision, and thank you.
Thank you. We'll hear from the appellant rebuttal.
Thank you. I'll be very brief. Just the construction that's urged by the appellees, it's untenable if you read the entire, provision as a whole. For the second sentence to have the effect that the appellees urge, it would render the first sentence completely irrelevant. How can you possibly have non-exclusive personal jurisdiction in New Jersey while simultaneously only having venue in New Jersey? The two can't meet. And so we would respectfully request that the court reverse the decision of the trial court and remand this case for further proceedings. Thank you.
Thank you. Our thanks to counsel for both sides. We appreciate your arguments this afternoon and your briefs on this. We'll take a short recess now to kind of move judges around and whatnot, but we'll be back in just a few minutes. Recess court for a few minutes.
All rise. This honorable court of Tennessee now stands in recess.